Hi, Assalamualaikum. My name is Anisha. So, for this assignment, we had been assigned with scenario 11, in which we had identified three legal issues. So, the first legal issue was whether Naki and Fiki can sue Nikki under negligence. The second legal issue was whether Naki and Fiki can sue Temco under negligence. And the third legal issue was whether the act of Fiki speeding up his car had contributed to the accident. Now, my friend Adnin is going to explain about the elements of negligence.
Assalamualaikum warahmatullahi wabarakatuh. My name is Anin Zuhaira and I will be discussing on whether or not the plaintiffs can sue the defendants for negligence. It is important to note that there are two plaintiffs and two defendants in this case. Firstly, the two plaintiffs are Naki and Fiki, while the two defendants are Nikki and Temko. So, there are four elements that will have to be proven in order to sue both Nikki and Temko. Firstly, duty of care that is determined by the capital test. Secondly, breach of duty of care. Next, damage due to the breach, and lastly, causation. In the case of Fiki and Nikki could foresee himself hitting another vehicle if he suddenly changes his lane. Although Fiki was partially responsible for speeding at the time of the accident, Nikki should be held responsible for changing his lane abruptly without looking beforehand, which led him to hit Fiki later, hence proving sufficient proximity and duty of care. Due to Nikki's breach of duty of care, Fiki was hospitalized for 3 months and paralyzed from his waist down. Multiple tortfeasors can be applied since Nikki deviated into the right lane to avoid Naki, which later caused a collision between Nikki and Fiki. With all the elements of negligence proven, Fiki can sue Nikki for negligence. Next, in the case of Naki and Nikki, Naki fainted and suffered permanent injuries after he was hit by the telephone pole. However, Nikki was driving carefully while following the speed limit, so there's no duty of care owed by Nikki to Naki, as the act of Naki running into the street was unforeseeable, and the snapping of the telephone pole was also unforeseeable. Hence, there's no breach of duty of care. The damages suffered by Naki was not caused by Nikki, and there's no causation to be proven. All the elements of negligence cannot be proven, so Naki cannot sue Nikki for negligence. Moving on to the case of Fiki and Temko, the incident where Fiki hits the telephone pole was foreseeable. However, the telephone pole was already there. The position of the telephone pole did not contribute to the car accident, which caused Fiki to suffer the said damages. Therefore, with insufficient proximity between the defendant and the damage suffered by the plaintiff, there's no duty of care owed by Temco to Fiki. Hence, there's no breach of duty of care. The damage suffered by Fiki was due to the car crash, and there's no causation to be proven. Thus, Fiki cannot sue Temco for negligence. And lastly, in the case of Naki and Temco, the possibility of the telephone pole snapping and endangering the locals of the housing area was foreseeable. Hence, there was a duty of care owed by Temco to Naki, who is a local of the said housing area. Temco had breached its duty of care by failing to perform any test to measure the durability of its telephone poles, which are made out of low-quality steel without any reinforcements. Due to this breach, Naki fainted and suffered permanent injuries after being hit by the snapped telephone pole. So, multiple tortfeasors again can be applied here, since Nikki and Fiki were involved with the car accident, which contributed to the snapping of the telephone pole, which hit Naki. So, with all the elements of negligence proven, Naki can sue Temco for negligence. Next, my friend Amza will discuss the relevant cases. Thank you.
Bismillahirrahmanirrahim. My name is Ahmad Amzar bin Azno Effendi. So now I would like to present two relevant cases that is related to the scenario. The first case is H-West and Son Ltd v Shepherd, and the second one is Nettleship v Western. I will only present the first case. The second case will be presented by my other group member, which is Farah Tasnim. So let's get straight into the matter of facts. The claimant was knocked down by a lorry, which was owned by the first defendant and negligently driven by an employee of the second defendant. She suffered severe head injuries, resulting in cerebral atrophy and paralysis of all four limbs. She lost the ability to speak and could communicate only through tiny movements of her eyes and required full-time care by nursing staff. Her life expectancy was estimated to be reduced to around 5 years, during which time there was no prospect of improvement in her condition. She brought an action for damages in tort of negligence against the defendant. So, what is the legal issue of the case? Whether the award of damages was so unreasonably high that it could be revised by the appeal courts on the basis on which this award had been arrived at was therefore in issue. So as the decision of the case, the House of Lords, affirming the decision of the Court of Appeal, held that although the sum awarded was high, it was within the scope of trial judges properly exercise discretion and should therefore stand. The Lord Reed and Devlin dissented on this point. The House also gave general guidance for determining damages in such specifically that the claimant's loss of happiness is neither a correct or practicable approach to determining damages. Thank you.
My name is Farah Tassim, and now I'm going to be explaining the second case that will be referred to in this scenario. So this is the case of Nettleship and Weston that happened in 1971. So let's first discuss about the material facts of this case. So this case involves an incompetent driver and also an informal driver instructor, which is the incompetent driver is the defendant, Mrs. Weston, and also the informal driver instructor is Mr. Nettleship, which is the claimant. So what happened in this case basically was Mrs. W wanted to learn how to drive, so she asked her friend, which is N, that will be referred to in this case, is that to teach her to drive. So Mr. Nettleship will agree upon one condition: if she had acquired an insurance that will cover him in any case if accidents happen. And upon that, Mrs. W agreed and also showed the relevant documents to prove that she had an insurance to cover if anything had happened. On their third lesson, after they stopped at the junction, Mr. N asked Mrs. W to move the car slowly round the corner to the left. So in this scene, Mr. N was in the driver's seat and Mrs. W was in the passenger seat. But they are both like trying to control the car, and Mr. N trying to teach Mrs. W how to drive. And after she was asked by Mr. N to move the car, she began to panic as the car was moving out of her control. And while that car was moving out of control, Mr. N tried to control the car but had failed to do so. So the car ended up striking a lamp standard, and Mr. N claimed the damages upon the harm that he suffered. The next element that we're going to discuss is the legal issues of the case. So there are three legal issues. Firstly, whether a learner driver has the same standard of care as a competent driver, and secondly, whether the claimant had voluntarily accepting the risk of accident by agreeing to help the defendant to teach her how to drive, and thirdly, whether the claimant is guilty of the contributory negligence. So these are the legal issues that has been raised upon in this case. Lastly, the decisions of the court. So both Lord Denning and Miguel LJJ had arrived at the final conclusion of both claimant and defendant had their fair share in the accident. Thus, the appeal was allowed and the damages would be divided half and half. So to conclude and all, why do we think that this case should be the main reference as in this scenario is that because this case involves a contributory negligence where the defendant and the plaintiff and the claimant has both fair share in the accident, and we do think that in our scenario, which is this scenario, the plaintiff and the defendant had also a fair share in contributing to the accident that already had happened. Thank you.
Moving on to the available remedy to the claimant. As it has been proven that there was indeed negligence in this case, both claimant Naki and Fiki can claim remedy from TEMCO and Niki respectively. The available remedy for Naki is general damages that he could seek from TEMCO. Generally, as Naki is a young victim, he is going to be awarded more compensation precisely because his permanent losses will impact a much longer portion of his life. In the case Rialas and Michel, as the plaintiff was still an infant, aged 6.5, the court had awarded his parent a total of €350,965 in damages, out of which €143,552 specifically for his future care and attention. So, looking at the current situation, Naki's parent, on behalf of him, can claim the reasonable value of medical supplies, hospital services, and healthcare services. Like the ongoing medical treatment, the parents are reasonably certain to experience up until he reaches the age of 18. In addition, his parents could also claim the legal expenses, including transportation to the hospital and the court, as well as the value of service the parents are reasonably certain to lose in the future until Naki is 18. In other words, how much time his parent had to take off from work in order to take care of him because of his permanent injuries. Lastly, they could also claim the value of the loss or reduction on Naki's future earning capacity as he is paralyzed now. As for Vicky, the available remedy is general damages that he could claim from Nikki. Due to the accident, Vicky was knocked unconscious and had suffered permanent injuries that he had to be hospitalized for 3 months and underwent several surgeries that left him paralyzed from the waist down. So Vicky can claim for his medical and legal expenses like transportation to the hospital and the court. Next, he could also claim compensation for his pain, suffering, and reduced quality of life or the loss of amenity due to the accident as he is paralyzed permanently. Considering that he is an adult, he could also claim for future losses of his earning up until his retirement date, as he is paralyzed and hence unable to resume working. In the case H. West and Son Limited and Shepherd, the plaintiff of the case was awarded a high amount of damages due to her chronic situation that was similar to our current claimant situation. So the court held that the sum is deemed appropriate for her condition. Looking at the current situation, it is reasonable for Vicky to be awarded a high amount of damages through the discretion of the court, of course, as it is proportionate and appropriate to his injuries considering that he is permanently paralyzed and it has just affect his lifestyle after the accident.
Hi, Assalamualaikum. My name is Anis and I will continue our discussions on the topic of valuable defense to the defendant. So in this case, there are two defendants, which is Nikki and Temko. So I will start first with the Nikki. So the defense that Nikki could raise in his case is contributory negligence. This is to argue that claimant is partially at fault for the harm done on them. And if this defense could be raised in a court, it will help to reduce the possible amount of damages the defendant, which is Nikki, need to pay. So there are two elements that Nikki must prove in order to raise these kinds of defense. The first one is he must prove that Vicky, which is the claimant, failed to demonstrate proper action for their own safety. In this scenario, we can see that Vicky was speeding over the speed limit in housing area, and when Nikki had to deviate on Vicky's lane, it was necessary to do so in order to avoid hitting child, which is Naki. So if Vicky did not speeding, he could prevent from losing control of his car and use the handbrake to brake the car before hitting the telephone pole. So therefore, it shows the first element already be proved that Vicky has failed to demonstrate proper action for their own safety. The next element is Nikki must prove that claimant's actions contributory cause of the damage suffered. So in this case, we can take a look at Vicky's actions of speeding causing him to lose the control of his car. So his losing the control caused him to hit the telephone pole, and the crash caused him to suffer permanent injuries. Therefore, it can be proved that Vicky's actions of speeding has contributed to the cause of the damage he suffered. So there are two cases that I referred to for this defense, which is Capps and Miller, and Nettleship and Weston. Moving on to the next defendant, which is Temko. So the defense that Temko could raise in a court is voluntary non-injuria. This is a defense that to argue that the claimant has consented to the harm that the defendant has done and voluntarily takes the risk of the harm. So there are three consent elements that defendant must prove in order to raise these kinds of defense in a court. The first one, it must be voluntarily. So it must show that it was Naki's free own choice and not forced by any other party to put him in this dangerous situation. We can see here in the scenario, Naki's action when he ran into the street, it shows that he has volunteered to the danger as nobody forced him to do so. He voluntarily put himself in the dangerous situation. Moving on to the second consent element that defendant must show, which is claimant's agreement to the risk. So this agreement may be expressed or implied by actions. In this case, Naki shows his agreement by his actions being on the street, demonstrating his willingness to the harm that might occur. So since Naki was a pedestrian, he was not supposed to be on the street as the street is for the motorists. Unless the injuries happened while he was playing football in the park, it might prove that he did not consent or agree to the risk happen. Last consent element that defendant must prove is that the claimant's knowledge of the risk. Naki might be a child, but there are some factors to consider that he will understand the risk. He is a 9-year-old with a disability, which is reasonable enough to assume that at his age, he could understand the danger of roadway. Assuming at the beginning that Naki has played the football on the street instead in the park, it could be proved that Naki at the first place did not have the knowledge of the risk at all. But according to the scenario, Naki could be found to play football in the park and not on the street, which shows that he knew the peril of it. Therefore, it proved that Naki understands the risk of playing on the street. And the case I referred to for this defense is Hall and Brooklyn's Auto Racing Club. Lastly, Temko could also raise the defense of contributory negligence. Like I said before, it is to argue that the claimant is partially at fault for the harm done on them. It also helps to reduce possible amount of damages the defendant needs to pay. Usually, it is uncommon to argue that a child under a certain age contributory negligent for their injuries. But in this case, it is expected for Naki to act according to his age to be aware of the danger of the road. I took the legal principle derived from a case A, B, and Main, whereby an 8-year-old child suffered from brain injuries because he was involved in a car accident for causing without properly checked the road. So in this case, he was liable 20% to the injuries because it was reasonable to expect that at his age, which is 8-year-old, to be aware of the importance looking left and right before crossing the road. Using the legal principle, TEMCO could already prove the element of claimant expected standard of behavior at his age, which is Naki was expected to understand the danger of crossing the road carelessly. And in this case, he crossing the road carelessly showed that he was below the expected behavior of a 9-year-old child would be. Lastly, Temco could also prove the last element, which is his failure behavior has caused the injuries. Naki carelessly ran into the street has caused Nikki to deviate onto Fiki's lane, which made Fiki lose control of his car and hit the telephone pole owned by Temco. And the pole split into two and hit Naki, causing him to suffer permanent injuries. Therefore, it could be proved that his failure behavior, which is Naki running into the street, has causing him to suffer permanent injuries. And that's conclude the final discussion on this video. Thank you for watching.